On this episode of Law Weekly, we focus on the disobedience of court orders, the poor funding of the judiciary, and much more. We have the views of a former president of the Nigerian Bar Association, Olisa Agbakoba, senior advocate of Nigeria. Also showing on the program, highlights from the annual Federal High Court Judges Conference, plus our weekly recap of the news from the courts and the Judicial Panel of Inquiries into SARS abuse and police brutality. Hello and welcome to the program. I'm Shola Shieli. The week began with the commencement of the Supreme Court's 2020-2021 New Legal Year ceremony. The Chief Justice of Nigeria was conspicuously absent at the ceremony, but that did not in any way take away from the shine of the event, which also saw the conferment of the rank of Senior Advocate of Nigeria on 72 legal practitioners. The most senior justice of the court, Justice Bode Rhodes-Vival, presided at the event, which was also attended by other justices of the Supreme Court, justices of other courts, senior advocates of Nigeria, and other lawyers. The Supreme Court expressed regret that some persons in privileged positions flagrantly disobey court orders. The court stressed that such acts of disobedience will no longer be tolerated.
Nigeria is not a lawless society, and no one, irrespective of his or her status, should turn it into one. Most times, some persons who, by sheer stroke of providence, find themselves in position of authority, flagrantly disobey lawful court orders and even make a boast of it.
Many legal practitioners have always expressed worry about this issue. My guest, former president of the Nigerian Bar Association, Olisa Agbakoba, is happy with the stance of the court. He believes it will send a clear message.
It will work. Because if you know that to not obey a judgment or a ruling or an order will land you in jail, then you will obey the order. There'll be less frivolity, what the late Justice Kayode Shaw called executive lawlessness. But because court orders are flouted, they're given and issued and flouted with impunity. So no one takes court orders serious. So that is a very important statement coming from the CJN. That if court orders are flouted, there will be some punishment. I hope it will work. That would be great.
I've also heard some senior lawyers say that perhaps one of the ways to go is when the executive brings cases to court, don't even entertain them.
Throw it out.
Throw it out.
Absolutely. The principle was laid down in Lagos State versus Ojukwu, when Ojukwu was put out of his premises by Lagos State, and the Court of Appeal put him back, and then the Lagos State refused to obey the order, and then appealed. It showed the principle. You can't be in disobedience of a court order and expect us to listen to you. So if the court in Nigeria, the Judiciary, High Court, Court of Appeal, Supreme Court, now become tough, we won't hear your cases, we will not listen to you, then we will see a change. But there's been a certain laxity since the great Shaw, court era. So nothing is taken serious. Look what the Supreme Court did in spite of 3 appointees of Trump. Texas brought a case to the Supreme Court to invalidate millions of votes. They didn't even listen to the case. It was thrown out. But I remember a weeping Amina Aogi. And I was saying, why is she weeping?
That's Justice of the Supreme Court.
Yes. Why did they take the case in the first place? Senior counsel abused their privileges by taking the same case to the Supreme Court repeatedly. In the case of Andy Uba, I think one senior counsel took it twice. You don't even give him the dignity of donning your robe and sitting in bank. At the registry to be thrown out. So when the courts begin to rise to the occasion, then people will react to the fact that here's a new mandate, there's a new sheriff in town, you don't mess with the judiciary. If you do so, no hearing. I welcome this new approach.
But there are those who now bring in the issue of appointment, of funding, that it might be a clog in this crusade. If the same judiciary goes to beg the executive for funding, then how do you say you jail their officers if they don't obey court orders? How do you think that will work out?
Any lawyer who has ever picked the Constitution will see the framework for funding in the Constitution. The judiciary is on first charge, means that the money for the judiciary is appropriated out of the Consolidated Revenue Fund, not the executive. That's number one. Number two, the National Judicial Council is responsible for putting together the budget estimates. So the judiciary is entirely separate from the executive in terms of funding. Unfortunately, the NJC hasn't done a good job. And as I was saying to a lot of people, I was a member of the NJC, Aluma Mukhtar was the CJN, and I said to her, you ought not to be going to the judicial, to the executive. And they were going. So I went to court. I sued the NJC, I sued the National Assembly, and I sued the Attorney General, and I won.
You sued the NJC?
Absolutely, because they're party interested, and I won. So I came back and said, well, I've gotten a victory for you. So now implement the decision of the court. So the NJC itself is not implementing its own decision, and they want to be tough on people. So it's going to be a tall order changing the mentality of the NJC, because they are the ones constitutionally empowered to carry the freedom of the judiciary on their head, and they're not doing so.
You said, unfortunately, the NJC is not implementing.
Yeah.
Because I hear complaints too that, well, we don't know how our budget was arrived at, how they...
They can't say that. Who's saying that? They can't say that. The NJC has the constitutional power to produce its own budget estimates. So I don't understand when they say they don't know how their budgets are prepared. They are the ones to prepare the budget. When they do so, they take it to the National Assembly for appropriation. But they have what's the word now? They have relinquished the power. So who does it? Ministry of Finance.
Which is wrong.
Absolutely wrong. Even on the authority of my case, it's absolutely wrong. Even on the authority of the Constitution. But the NJC is not rising to the occasion.
How do they rise to the occasion?
They simply will take the damn budget estimate and go to the National Assembly. What's holding them? Have they done that? They haven't done it. So every year, the Finance Ministry appropriates the budget. So that's their problem. But let's see the judiciary clash with the executive, because the judiciary would say to the executive, to prepare our budget is a naked usurpation of our functions. Please, can you leave us alone? The Constitution says we will prepare our budget estimates and hand it down to the National Assembly. And we should not be getting statutory allocation. If you look at the budget estimates, you will find that there is statutory allocation. And then the money is released to the NJC by what they call envelopes. No, Section 87 sub 4 says all the money standing to the credit of the NJC in the appropriation bill, now the budget, will be transferred to the NJC. That gives them independence. So they first have a duty constitutionally backed to prepare their budget. They have a constitutional protection to take all their money in one fell swoop. The argument has been, well, there's no money. So, okay, that's a different thing. But let the money be appropriated by the NJC. That will change the picture. It's a shame when I see people like Wike building houses for judges and feeling very tough.
And other governors too, buying
cars. Come on. How can they be independent? If the CJ of a particular state knows that the governor will buy a house for him, then he's not likely to take decisions that will affect the independence of the judiciary. So they are their own problem, the NJC. They have to wake up.
Is that foreclosed with this budget cycle? Because we are in another budget cycle, and the judiciary has started complaining again because it's the same statutory allowance.
Okay, I'm not the judiciary. Go ask the CJN.
But what do you think?
It's their problem. I'm not interested. I'm not in the judiciary. I'm just setting out what they ought to do. What they ought to do. If they want to do it, fine. If they don't want to do it, don't complain. Don't wimp. It's not for me to say whether they should do it. All I can tell you is that what is going on now is wrong. So if they are listening, then let them do the right thing, whether it's in the context of 2021 budget or henceforth. But let the NJC stand up to its constitutional powers. Let it invoke its powers and do the right thing. And then we'll see a different judiciary. And then the rule of law will change. Impunity will stop, because an independent judiciary, as we have seen in America, Mr. Trump filed 50 cases across America, didn't get one. If the judiciary was a weak institution, it would have succumbed. But here, the judiciary is not a strong institution. That's why we do not have respect for judgments. So that funding thing is crucial to democracy and consolidation of our electoral process. So I hope that they will wake up. They need to wake up.
The issue of salaries too.
It's all tied in.
It's all tied together.
It's all tied in.
It's the same process.
It's the same process. It's all tied in.
Because I hear that the last time their salaries were increased was over 12 years ago.
Nothing apart from that. The fact is that they don't even control it. But look at the National Assembly. I'm not saying they should go and do what the National Assembly is doing by fixing salaries that are beyond the prescribed amounts. But it is for the NJC to fix the welfare of the judges, deal with their courtrooms. I mean, look at the Federal High Court. You are familiar with the Federal High Court. It's pathetic. How many judges have more than 2 or 3 qualified staff? But a minister has about 16. So there are so many things wrong with this lack of funding. So many things. Look at the Federal High Court building in Lagos. It's been going on for the last, 10 years. Forever. So money is crucial to how the NJC and the courts work.
I also wanted to talk about one other issue that came out from that swearing in, apart from the issue of disobedience of court orders, was also the issue of this backlog of cases that we continue to see. I know you've consistently said something about the speed of justice and the need to do something about it. But it just seems that the problem continues to persist. Every legal year we're talking about this issue. What has to give?
A very, very visionary CJN. That's what has to give. You have to have a very visionary CJN. There are lots of things that can happen. But the first thing is a CJN who says, I'm going to resolve the problem. The framework of the Nigerian judiciary can be found in the English Judicature Act of 1875. So judges who sat on the bench in the 1880s in England, were they to resurrect from their graves, they will be familiar with the Nigerian system. Isn't that a big shame? We have not advanced. The rules of court are old, archaic. There's no speed. There's no case management. These are the issues. So what we need to do is to say we have to introduce speed of justice. A victim of this process was actually Achibong, Justice Achibong.
Charles Achibong,
because he
of
was
the Federal High Court.
His removal was tied to his efficiency. He couldn't stand, lawyers rigmaroling, and he threw out cases. That's what I want to see. Judges are far too lenient. This issue of, they don't descend to the arena, so they stay and listen to hogwash and rubbish. That's what slows the cases down. But you see,
should they start descending?
Absolutely, absolutely. Do you watch Judge Judy? You watch Judge Judy? I want to see that. Active. If you are talking nonsense and you're absolutely lying, I'll cut you off. The judge ought to do justice, not to allow lawyers take control of the courts. It is the judge who controls the case in the interest of the litigants.
Curious as to what you said about, seeing a Judge Judy kind of proceedings in our courtrooms, which will fasten and the things that happen. But I'm also, one of the things that I know people will say is that when the judge descends into the arena, then there's likely to be issues of bias. As we just saw with the Odisa Metsu case.
You are abusing people. That's not
it's not the same thing.
You are descending to the arena on issues.
Okay.
For instance, Justice Adeniji once descended into the arena. So I was doing an insurance case. And objection, because it was a photocopy. Justice Adeniji said, Mr. Sit down. Objection to what? The original is on the car. You see? Otherwise, he would have taken objection,
arguments,
ruling
from both sides.
So the judge would descend to the arena, and it is not called descending, it's called case management. You manage your case. So when a lawyer makes a frivolous application, I don't have to hear the other side. Who says? I'll just tell you your application is frivolous and is bound to fail. And I would not allow you to deviate from justice, because I know that the client standing there is interested in, when can I get my house back? When can I get my money? He's not interested in the clash of lawyers, using rules of court. So if the lawyers are positing their interests and it is standing in the way of the interest of the client, the proper function of the judge is to open it and get to the chase. That's the function of the judge. Right. If that happens, things, the judges switch in court like this. Yes. That's all they do. Yes. You don't know whether the man is asleep or awake. Some of them, you can't see their faces because in the Lagos High Court Criminal Division. You can see their faces. Why are they interacting? The judge must interact. He must remove the rubbish.
He must be forensic in his approach.
Absolutely.
Okay.
He must say, look, I've read the papers. I've read the papers. This issue is about this. He summarizes it. So you tell me, I want to hear only that. Not a long-winded, the master of this was Chief Williams.
There are judges like that, though.
There are very few. I agree, but there are very few. You got to know what you've come to court to do. That's why Chief Williams was such a master. He knew what to do when he came to court. He would ask the right questions. Bernard Longe versus First Bank, Chief Williams finished the case in 12 minutes with 3 questions and got Richard Akinjide scrambling for an adjournment because Akinjide thought it would be the usual, what is your name? Came to the point. He understood that you cannot remove an MD of a bank without statutory approval. That was the issue. So he didn't go to say, how long have you been MD? So when you have lawyers who understand the issues and judges who understand the issues, you can finish a complex case in a week.
Welcome back. Staying with the judiciary, the Chief Judge of the Federal High Court, Justice John Sowo, has read the Riot Act to the judges, saying they must always be wary of actions capable of presenting them and the court in a bad light. He made this comment at the unveiling and presentation ceremony of the Federal High Court Law Reports 2013 and 2014 and the formal opening of the 36th Annual Judges Conference, which held in Abuja.
Thank you very much, boys.
Just like it was with the Supreme Court's Legal Year ceremony, the Chief Justice of Nigeria was also absent at the Legal Year ceremony of the Federal High Court, prompting the Chief Judge of the Court, Justice John Sowo, to declare the ceremony open.
I confer that authority upon myself to declare it open, and I so declare. Thank you very much.
After this, the CJ dwelt on what the court had to go through this year, especially with the COVID-19 pandemic. With the growing number of cases, Justice Sowo says the court is set to appoint more judges.
The process of appointing new judges has commenced. However, efforts will be made to ensure that there is equitable representation on the bench of the court. I will continue to urge your lordships and staff to put in more efforts to tackle the upsurge that will follow the eventual control of the virus with regard to increase in the number of cases and attendant services.
With the ICPC Nigeria Corruption Index ranking the judiciary tops, the CJ says he's glad that the Federal High Court judges exhibited integrity in the discharge of their duties with the Edo and Ondo governorship elections.
I'm also happy that the court and her judges were not captured in any negative news as a result of the elections held in Edo and Ondo states, respectively. I encourage your lordships to always be wary of actions that will put us, and indeed the court, in bad light. We have managed in this new beginning to arrange interactive discussions in the course of the conference. It is my hope that your lordships will appreciate such arrangement to the glory of God Almighty.
After his speech, the court unveiled the Federal High Court Law Report of 2013 and 2014.
So, behold the Federal High Court of Nigeria Law Reports. You can endeavor to take copies. I believe they are not also expensive. So, thank you very much.
And on the home stretch, we bring you a recap of some of the major activities from the judicial panels probing police brutality across the country.
We begin in Bayelsa State, where the Judicial Panel of Inquiry on Police Brutality and related extrajudicial killings has held its inaugural session with 19 petitions received so far. The session began with an assurance from the chairman of the Judicial Panel, Justice Young Ogola, that all petitioners will be given fair hearing.
As I can see from the petitions, Some may require visit to the locus. This, though, will be subject to availability of funds, time, and another factor we are going to consider seriously is security. Whether it will be safe enough for us to go to those places and carry out this assignment. You know, as I do, that every dispute has at least 2 or more parties to it. Therefore, to do a good job, the panel shall respect the principle of rule of law, which requires us to hear all sides.
The police also made a promise to fully cooperate with the panel. The panel has adjourned to the 6th of January 2021 as the respondents were yet to file their responses. In Taraba, the absence of the police is slowing down proceedings at the panel hearing cases of police brutality. The chairman of the panel, Justice Christopher Anwobra, describes the action of the police as a deliberate attempt to delay and frustrate the hearing of the petitions. Specifically, the Commissioner of Police in the state and one officer, Matthias, of the intelligence response team, who were necessary, were said to be absent.
In the preview of fair hearing, we are forced to allow a further adjournment for the last time at the instance of the third respondent. At the next adjournment, if he does not appear, we will proceed to hear this petition.
In Edo State, members of the Association of the Deaf are asking to be heard and carried along in everyday issues. Some members of the association made the appeal before the Edo State Judicial Panel for Victims of SARS and related abuses. The association had filed a petition on behalf of one Mr. Bright Osarabo and one Mr. Festus Obaze, allegedly shot on October 20th. One of them was allegedly shot by the police and the other by a soldier during the curfew in the state after hoodlums hijacked the NSAS protest in Benin City, the state capital. Away from the judicial panel, but still in Edo State, the Governorship Election Tribunal will, from January 11, 2020, decide the fate of Governor Godwin Obaseki, his deputy Philip Shuaibu, and the People's Democratic Party, and the Independent National Electoral Commission in 4 of the 5 petitions filed at the tribunal in Benin City. The Justice Yunusa Musa-led 3-member tribunal disclosed that the hearing in the 4 petitions will hold separately on January 11th, 12th, and 13th, 2021. The 4 petitions before the tribunal were filed by Action Democratic Party and its governorship candidates, the Action People's Party, the Allied People's Movement, and Tracy Agol of the New Nigeria People's Party. In the nation's capital, the Court of Appeal sitting in Abuja has nullified the conviction and 7-year jail term imposed on a former spokesperson of the People's Democratic Party, Olisametu, by Justice Okonabang of the Federal High Court, Abuja. A 3-man panel of the court, led by Justice Stephen Ada, in a unanimous judgment, held that the proceedings of the Federal High Court leading to the conviction of Mr. Metu and his company, Destra Investment Limited, were tainted with bias and could not stand. The appellate court therefore ordered that the trial be conducted afresh under a new judge. The court has also set aside the indictment delivered by Justice Okonabang against a former National Security Advisor, Colonel Sambo Dasuki. Justice Ada held that Colonel Dasuki, not being charged as a co-defendant in the case, was not given any opportunity to defend himself on the damaging comments made against him. And we round off with the report that 2 non-governmental organizations, Paradigm Initiative and Digital Rights Lawyers Initiative, have filed a suit at the Federal High Court, Lagos, to stop the proposed blocking of SIM cards not linked to the national identification numbers. The suit was filed against the Minister of Communications and Digital Economy, Dr. Ibrahim Pantami, the Ministry of Communications and 4 network operators, MTN, Glo, Airtel, and 9 Mobile. In the suit, the applicants are asking the court to declare that the proposed blocking of SIM cards that are not registered with the national identification numbers will likely interfere with the right to freedom of expression.
And it's on this note that we adjourn till next week. Don't forget that you can watch this episode of the program and past episodes on our YouTube channel. I'm Shola Shayeli. Thank you for watching.